Deputy Speaker. It's always a pleasure to follow the Chairman of the Home Affairs Select Committee, and doubly so since he was so kind about me in his speech. He speaks with great authority on all of these issues. He tempts me into the issue of appeals in relation to family immigration, but I hope people understand if on this occasion I rise to speak about one specific clause in this bill, and that is clause 37, that deals with the issue of drug driving. On the 26th of June 2010, my constituent, Lillian Groves, was killed outside her house. She was just 14 years old. The driver of the vehicle that knocked her down was driving a car that wasn't licensed in his name. He had no insurance to drive that vehicle. He was driving at 43 miles an hour in a 30-mile-an-hour zone, and a half-smoked joint of cannabis was found on the dashboard of the car. When the police found him, he wasn't at the scene of the accident. He had gone some distance down the road. I hope the House won't mind if I pause for a second to reflect what Lillian might have done in the rest of her life. The people whose lives she would have touched, the children she might have had, the contribution she might have made to our local town. And it's not just the loss of her life, but also the impact it's had on her friends and also most particularly upon her family. She was taken to hospital and she was pronounced dead some hours later. Sadly, the driver of the vehicle, his blood was not tested immediately. Only after Lillian died did the police conduct a test. There was cannabis found in his blood. The family have never been told the level of cannabis that was found in her blood, but they were told by the CPS that it was not sufficient to warrant a charge of causing death by careless driving while under the influence of drugs. The driver was sentenced to just 8 months in jail. He served just 4 months and was released. He lives very locally to the family, so they are faced for the rest of their lives with the knowledge that every time they go to the local shops, there is a danger that they will bump into this individual who has never spoken to them, never apologised or shown any remorse at all for what he has done. To my mind, and I think to the minds of all of my constituents, and I hope to all members of this House, that family did not receive justice in any sense of the word. I want to pay tribute to them today, to Gary and Natasha, Lillian's parents, and to Michaela, her aunt. A number of members, the chairman of the Home Affairs Select Committee and the Home Secretary among them, have been very kind to give me some credit for the campaign I've run. But I really don't feel that I deserve any credit at all. I'm just doing my job. The people that deserve credit in this instance are Lillian's family. And they deserve credit because they took a terrible situation that no parent would ever want to endure, and rather than be consumed by anger, as I fear many of us would, they wanted to turn it into something positive. They wanted to see a change in the way that we as a society deal with this issue, so that other families did not have to experience the anguish that they did. And they found a powerful and useful friend in our local paper, the Croydon Advertiser, and in particular an excellent young reporter called Gareth Davis, who worked with them to put together a campaign for what they have called Lillian's Law. And they came to see me at my surgery to ask for my support. And this package that they were looking for contained 4 items. First of all, they wanted to see, Mr. Deputy Speaker, a change in the law itself, because, as the Home Secretary alluded in her speech, at the moment under the law, it is an offence under Section 4 of the Road Traffic Act 1988 to drive whilst impaired by drugs. But it's extremely difficult to secure convictions under that piece of law because it is difficult for the prosecution to prove impairment. There isn't a law that is equivalent to the law in relation to drink driving, where having a level of a drug in your blood system over a certain level is held to be evidence of impairment. The law isn't weighted in the same way. So the first thing was to look to change the law, and that's what this bill does via clause 37. But I hope the House won't mind if I mention a couple of the other things that they are also looking to see happen. The second thing is to have a device, initially for use in police stations, but in the longer term for use at the roadside, equivalent to a breathalyser. At the moment, the police conduct a sort of field impairment test, and then a suspect can be taken back to a police station. A doctor has to be called to conduct a blood test. That's expensive, it's time consuming, and therefore there is a disincentive to conduct those kinds of tests. So it's very important that we get devices in place that allow equivalent tests to be done to those that we see in relation to drink driving. I'm very pleased that the government has recently given type approval for devices for use at police stations, and I understand that perhaps ministers could confirm when they sum up that the intention is to approve a device for use at the roadside by 2014. The third issue was to look at the issue of sentencing and making sure that there is appropriate punishment for those that are convicted of these offences, and the legislation that is before the House today provides an equivalent level of sentence to that in relation to drink driving. And the fourth, which can only happen when the other three pieces of the jigsaw are in place, is to look at an enforcement campaign similar to that which we saw in the 1980s in relation to drink driving. Now, there was a time in our past when lots of people drove under the influence of drink. It was the cultural norm to a degree, and it took that enforcement campaign in the 1980s to change attitudes. And I think that we need a similar kind of campaign in relation to driving under the influence of some drugs, which is sadly all too prevalent in society today. So when the family came to see me in my surgery, I was faced with the challenge of what to do, how to help them, how to assist them. And the House of Commons Library, as usual, provided a great first start in doing some research on the law and previous efforts to change it. And to be fair to the last government, this was an issue that they had looked at. It was a difficult and complicated issue because a number of different government departments were involved. The Home Office in relation to the police's responsibilities, the Department of Justice in relation to the criminal offence, and also the Department of Transport. So the decision I took was that the right thing to do was perhaps to try and give this issue a profile right to the top, and I raised it at Prime Minister's questions. And I want to put on record my thanks to the Prime Minister because he agreed to meet the family. He invited them to 10 Downing Street to see him. And I guess they found in him a member of this House, one of the few members of this House that sadly can understand exactly what this family had been through in terms of the loss of a child. And he's worked, the staff at Number 10 have worked closely with all three government departments to get through rapidly this change in the law that we see before us today. I want Mr. Deputy Speaker just to raise a couple of questions in relation to the detail. And I think that the Honourable Member for Cambridge was alluding to this in a question that he asked the Home Secretary earlier, in relation to what the limits for specified drugs might be. If we look at the legislation, subsection 1(9) is relevant here, and it provides that specified limits could be 0. There's a wonderful sentence in the explanatory notes for the bill, which are always such a great source of guidance to us all, where it says, and I quote, paragraph 562, new section 5A brackets 9 brackets provides that specified limits could be 0, though this does not mean that limits would in fact be 0. So one can make of that what one will. I know that Lillian's family feel very strongly that in relation to illegal drugs, they would like to see the level set at 0. They feel, as a matter of principle, people shouldn't be taking these substances and therefore shouldn't be driving under their influence. But there is a strong counter-argument that we should be led by science here. I think it's the point that the Honourable Member for Cambridge was trying to make, that we should be led by the science, that we should try and discover what level of an active substance in the bloodstream leads to an equivalent level of impairment that the blood alcohol limit provides, and set the limits in those ways. And clearly we also have to look, as the legislation tries to do, in relation to some prescribed medication that has the same active substances as some illegal drugs. And I will certainly give way to my friend.
Later to his speech, but particularly commend him for his leadership on driving through this important change. Does he agree, though, in terms of the impact, in terms of the sentencing impact? Because following, let's say, through the safe passage of this proposal, the outcome will be a sentencing maximum of 12 months. Given the fact that those impaired through being over the limit, whether drugs or alcohol, plainly there's inherent carelessness of that. But it is only if they were charged under causing death by careless driving whilst under the influence that they would have a sentence that got into the Crown Court for a much more heavy sentence, which is what many of these people deserve.
I think that, as usual, my honourable friend makes a very good point, and I was going to come on and explore those issues in a second once I've dealt with the issue of the limits. So I think that there is this decision to be made in relation to whether the limits are set as far as possible, advised by scientific evidence that is looking for a similar level of impairment to alcohol, or whether there is a case, as the family would like, to look at zero limits for some of the most serious substances. And the government, as I understand it, has set up the Wolf panel to look at the detail of this. I think they themselves are finding this a highly complex and difficult area and are taking a bit more time than was originally envisaged to do this work. But I'd be grateful for any guidance that ministers could give in the wind-ups as to the timing of the panel's report. I can see the Honourable Member, I've tempted the Honourable Member for Cambridge.
I thank you for giving way, and it is a fascinating balance to try to work out how to... I've seen some of the comments from the Wolf panel which suggests that actually alcohol is by far and away the most dangerous substance people could take. And so while I think there is a very good case, I do support this legislation if it's aimed at reducing impairment, perhaps more work still needs to be done on drink driving as well.
The Honourable Member for Cambridge, certainly, Madam Deputy Speaker, makes a very powerful point. I'm conscious of the time and other members wish to speak, so I will just end by addressing the sentencing point that the Honourable Member for Enfield Southgate raised. The explanatory notes here make an interesting point. They say that the sentencing is being set at the same level in relation to driving under the influence of alcohol. And there's a phrase in paragraph 560 which says that these are the penalties set out in Schedule 2 to the Road Traffic Offenders Act 1988 as increased for England and Wales by certain provisions of the Criminal Justice Act 2003, which are not yet in force. So I wonder if ministers could give some guidance about what these provisions of this Act that was passed 9 years ago are and why neither the previous government nor the current one have yet brought them into force. But paragraph 567 of the explanatory notes also, Madam Deputy Speaker, makes an important point which I think answers my honourable friend for Enfield Southgate. And it says that paragraph 2 amends section 3A of the 88 Act so that if the person had a controlled drug in the blood or urine in excess of the specified limit for that drug, the person could be charged with the more heavily penalised offence in that section of causing death by careless driving. So I believe that is saying, and I'd be grateful if ministers could confirm, that the limits that we're talking about here will apply to both offences, and that in the case of my constituent Lillian, given that she was killed, if the driver's cannabis level had been above the limit that is subsequently set, then that more significant charge could have been brought against that individual. In conclusion, Madam Deputy Speaker, as I said, I would like to end by paying tribute to Lillian's family for the work that they have done in advancing this cause. The House will know that Lillian is far from the only individual that has been affected whose life has been sadly brought short by a drug driver. Other members of this House will sadly no doubt have examples from their own constituents. But for me, as the Member of Parliament for Croydon Central, it has been a great privilege to be able to speak up on behalf of this wonderful family who want to ensure that other people do not go through the agony that they have experienced. And I thank my right honourable friend, the Prime Minister, and all the ministers involved that are responsible for bringing this legislation before the House.
Green.